My name is Equitable Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. Today I want to talk a little bit about the determination or the resolution of property settlement issues in a divorce. What do we consider when we're dividing marital property? Well, first of all, the first thing we have to do is figure out what is marital property. Just because you're married and just because you have it doesn't necessarily mean that it's going to be determined to be marital. Sometimes people have things in the marriage which are oftentimes by the court determined to be non-marital. Like, for example, the court may find that a certain item is a family heirloom and therefore is separate property belonging to dad or belonging to mom. You may have had access to it. Both parties may have had it on the mantle forever, and the grandfather's ashes or something like that. But come time for a divorce, the court's not likely to say, well, it belongs to both, so we're going to divide the ash in half let's get two Sanka cans. The court's not going to do that. The court is likely to say, okay, these are the paternal grandfather's ashes, that's where it's going to go. It's an heirloom and we're going to keep it that way. So it's important to determine, is it a marital asset at all? The rule of thumb generally is that if it was accumulated during the marriage and it's not a family heirloom, like let's say you bought a house after you were married 2 years, it doesn't matter in whose name that property is. Ultimately, the court will look at that and say, you know what, it was bought during the marriage, it's a marital asset. So the when question becomes important more than the what. In other words, when was this acquired? Was it acquired during the marriage? Then it's a marital asset. Now, once it's a marital asset, the court is charged with the responsibility of equitably dividing the marital assets in a divorce. Now notice the terminology. Equitable division is not the same as equal division, okay? Equitable means a fair division. Sometimes it's fair to divide things exactly equally, and every effort will be made to do so. Sometimes it's equitable or fair to divide something not exactly equally. And you might get 55-45 instead of 50-50. You might even get 60-40. I will tell you that when it comes time for dividing property, while Michigan is a no-fault divorce state for the purposes of getting a divorce, meaning you don't have to be proving fault in order to be granted a divorce, with respect to the property, the court still looks at fault with respect to how we divide it. That said, the court will very, very rarely utilize fault to make a significant swing in the property settlement. In other words, the court might utilize fault and find 55-45, or maybe 60 to you, 40% to him or her. The court might do that. Even the 60-40 is pretty rare, but you're not going to see 90-10, and you're not going to see 80-20, even in cases of egregious fault, where there's spousal abuse or there's some kind of serial affairs that one party's conducting throughout the marriage. The court is not likely to find a huge disparity between the parties as it divides up the assets equitably. Like I said, it might do 55-45 or a little bit more, but it's not going to do 90-10. So when we're considering how to divide up marital assets, we number one got to find, is it a marital asset? And for that we ask the when question, when was it acquired? And number two, the court will usually try to do it fairly. Sometimes that means equally, sometimes not. The court, for example, might find an unequal division is appropriate where one party earns significantly more than the other and is better able to recoup from the losses in the marriage. Sometimes the court may find that because of the amount of property that the person brought into the marriage, which is separate, that they're quite wealthy on their own and therefore might make a slight difference in the equitable division. Even that is questionable. But in your case, of course, everything is different and everyone is fact specific. If you have questions about your matter, reach out and we'll be glad to help you out.